Assalamualaikum and a very good day to all. So we are from tutorial group Tuesday 2 to 3 p.m. So our group members are me, myself, Nur Asli binti Kamaruddin, Raudah binti Mazman and Nur Afilah Shaza binti Arifin. So today we are going to present about problem set 11 question 2.
One of Lisco's subsidiaries required funding as working capital and borrowed Rm 8 million from State Bank and in return charged its entire assets and undertaking in favour of the bank. The charge was duly registered with the company's commission. The charge contained the following clause, which is no subsequent charge or charges ranking pari passu or in priority with the existing charge may be created or shall be registered by the company without the consent of State Bank. So the subsidiary subsequently obtained a loan from Maju Bank and charged its land in favour of Maju Bank.
We have identified there are two issues in this particular question. So the first issue is how to determine the priority of the debt when the company is wound up, and the second issue is would the answer be different if the unsecured creditors who petitioned for the wind up of the company had obtained judgment prior to the petition being presented. The first issue in this case is how to determine the priority of the debt when the company is wound up. So, before that, Section 4 of the Companies Act stated the definition of charge. A charge includes a mortgage and any agreement to give or execute a charge or mortgage, whether upon demand or otherwise. So, there are two types of charge, namely fixed and floating charge. Fixed charge is defined as anything attached to a specific item and the company cannot dispose of the property without obtaining the consent from the lender. So example of fixed charge are land and buildings, a ship, a piece of machinery, and intellectual property such as trademarks and others. So, meanwhile, floating charge is defined as a charge of a class of assets of a company from present and future. So, the asset will be changing from time to time, and in the ordinary course of business, and the company may deal with the asset in question until some future steps taken by someone who has interest in the charge. So, for example, the stocks in a company. Okay. Then, a second floating charge may be created in ranking pari passu with a prior floating charge. So, for example, in the case of Ray Benjamin Cook, the case stated that where a company has created a charge over the whole of its undertaking, a second floating charge would take priority over the prior floating charge unless the terms of the prior floating charge allowed the company to create subsequent charge with an equal or higher priority.
Applying to this case, we need to identify type of charges that Lisco subsidiary made. Lisco subsidiary charged its entire asset in the first charge with State Bank. An asset is considered as a floating charge. This is because asset is always changed by time to time. In the case of Real Yorkshire Wool Combers Association, it stated that if it is a floating charge if it is a charge on a class of asset of a company present and future. If that class is one which, in the ordinary course of the business, of the company would be changing from time to time, and if you find that by the charge it is contemplated that until some future step is taken by or on behalf of those interested in the charge, the company may carry on in its business in the ordinary way as far as concerned the particular class of asset. However, that a charge may be classified as a floating charge even if the charge does not contain all the characteristics that has been stated. As for the second charge made by the LISCO subsidiary, which is land, it is a fixed charge. The features of a fixed charge is that when it is registered, it will confer immediate protection and security to charge holder. Under section 108 subsection 3, it listed 10 categories of charge, which is charge of land and either movable or immovable property. Priority of that can be determined by the four factors, namely whether the charge was registered, whether the charge is fixed or floating, when it is a floating charge, whether it crystallized on commencement, on winding up or prior to that, and whether there are preferential creditors. In order to have security over the charge need to be registered under section 108 of the Companies Act 1965. If the charge is not registered, section 108 subsection 2 stated that non-registration renders the charge void vis liquidator and creditor, but this does not affect the obligation to repay the money under section 108 subsection 3. Registration of charge protect the charge's priority over later registrable charge. A charge that is registered earlier than another charge will have priority over it, even if the second mentioned charge was created before it.
Next, a fixed charge will rank above a floating charge, assuming that both were registered even though the floating charge were registered earlier. Meanwhile, a floating charge has no priority over a legal charge unless it was created earlier and it has a clause prohibiting the creation of subsequent charges without the holder of the floating charge consent and the legal charge having knowledge of it. In Malaysia, priority creditors include the costs, charges and expenses of the insolvency, employees' wages and entitlement and federal taxes, including goods and services tax. The preferential creditors was stated under section 292 clause 4 of the Companies Act 1965. Normally, in a winding up, unsecured creditors are paid after the secured creditors are paid. However, if the company have preferential creditors, they have priority over the holders of the ventures of the company secured by a floating charge. These preferential creditors ranks amongst themselves according to the sequence in section 292 clause 1 of the Companies Act. So, applying in this particular case, the priority of debts can be determined by first looking into whether the charge is registered or not, types of the charge, if the charge is floating, whether it is crystallized, and identify if there is any preferential creditors. In addition to the second issue of the case, the answer would be different if the unsecured creditors who petitioned to wind up the company had obtained judgment prior to the petition being presented. Beforehand, the general rule is that upon commencement of winding up, company has unsecured creditors, they will be paid after the company's assets have been used up to pay the secured creditors. An exception to this general rule is that when a floating charge involved, if the unsecured creditor obtains a judgment for the debt against the company before the floating charge crystallized, the unsecured creditor will be paid before the floating charge. This means that the position of unsecured creditors who had obtained judgment prior to the petition is just the same as the secured creditor. Therefore, for the second issue, yes, the answer would be different.
In conclusion,
LISCO subsidiary have to pay all the debt according to the debt priority, which are registration, type of charges, crystallization, and other preferential
creditors.
As for the second issue, the answer would be different if the unsecured creditors have obtained prior judgment before the petition would not have been represented.
That's all.
Bye-bye.